So what along this journey crippled him, broke him? What tainted him? What poisoned him? So the question is, what brought you to this moment? And then I think the more important question is, what are you going to do about it?
Right.
And those are our redemption stories.
Right.
I didn't see any of that here.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, it's Doug Passon again, here not in Studio 3553, but that's okay, helping us get set for sentencing. Again, our returning champion, Mark Allenbaugh. We've been talking in previous podcasts about all these high-profile sentencings at the end of 2022 that we didn't have time to get to, and we're playing catch-up. And so in the last, in the sort of umbrella episode that we did to sort of set all these up, Mark Allenbaugh did an amazing kind of synthesis. Is that a good word, Mark? Synthesis?
Yes, very good word.
Thank you. I like that word. He did a synthesis of all these high-profile cases that we're talking about. We're talking about Sunny Balwani and Michael Avenatti and the Chrisleys. And so I want to send you back to the Sunny Balwani episode, just if you really want the big picture takeaways. Spoiler alert, guidelines broken. But Mark lays it out so eloquently. We debated whether or not to just duplicate it here. We're not going to. I want you to go back to the Sunny Balwani episode, links in the show notes, and get the big picture. And we're going to talk a little bit more about Michael Avenatti's sentencing. So let's just dig in, because there are still some lessons that we can learn and big picture takeaways. So, Michael Avenatti, obviously you probably know him. He was, I guess it's fair to say, was a lawyer, because he's probably never practicing again. Probably already had his ticket punch, but convicted in Southern District of New York for stealing Stormy Daniels' book royalties, for shaking down Nike. Then he goes back to the West Coast, and he's got a whole other case for stealing money from his clients. And he's all sentenced there. The advisory range, I'm going to throw this to you, Mark Allenbaugh, but just let me set it up real quick. The guideline range, he pled guilty without a plea agreement, which is the thing that people do, right?
Pleading open. Yes.
Yeah. Most of the time there's a written, just so people who aren't so familiar with this, most of the time there's going to be a very thorough written plea document. It looks like a big contract in a legal contract.
A plea agreement.
Plea agreement, right.
Yeah.
And it's set, and the government sets forth what they agree to do, and the defense sets forth what they agree to do, and it's got the factual basis. It's all a bunch of stuff.
Right.
But in this case, Michael Avenatti just said, no, I'm just going to plead guilty to everything without a plea agreement, straight, what we call pleading straight up to the court. And we'll just, I admit what I did, and we'll just fight out all the other issues of sentencing. So that's what he did.
And by the way, we should add the upside for doing that is you preserve your right to appeal.
Yeah.
So you give that up when you plead guilty.
Yeah, that's an important and interesting kind of tidbit, and not inconsequential, which is, the government, who has all the power in plea negotiations, right? They have the final say in what to charge, how to charge, and what kind of a plea to offer. And if you don't like it, you don't have to take a plea, or you can plead straight up like Avenatti did.
Or go to trial.
Or go to trial, which is, of course, never happens. And maybe in 4% of the cases going to trial, but
less than 3%. But
oh my God. Yeah. Okay. So 97% of every federal case is going to be a plea, which is a whole other podcast, but that's not good. The point is, if you went to trial and you lost, you'd have an automatic right to appeal, which means you get a higher court to review everything that happened in a lower court to make sure there were no mistakes, legal or otherwise, right? Well, I don't know if there's otherwise, but no legal mistake. But when you plead guilty, the government forces you almost always to give up your right to appeal the sentence.
Correct.
Or appeal anything, basically.
Correct.
There's
even a mistake in the guidelines.
Even a mistake in the guidelines, which to me sounds coercive. And you know, I guess that's a whole other podcast. But you know, there are a couple exceptions that are carved out in most jurisdictions, which is you can challenge ineffective assistance of counsel or government misconduct.
Yes.
But that's very difficult to prove. And
correct.
So anyway, yeah. So he pled straight up. The guidelines calculations comes down. It's 262 to 327 months. I hate talking in terms of months because it seems like no big deal. That's a lot of years.
Yes.
And that is if he gets acceptance of responsibility.
Correct.
Which is a guideline reduction when you plead guilty and you say I'm guilty, you get some credit for just basically saying I'm guilty. But sometimes even people who plead guilty don't get acceptance for various reasons. And if the guidelines didn't give the 2 or 3 levels off for acceptance, his range was 324 to 405 months. The government asked for, at sentencing, 210 months if he gets acceptance and more if he didn't. That's 17 and a half years. So obviously, Mark, 210 is less than 262 and a lot less than 364. I think it's super interesting place to start that even the government is asking for a way below guideline sentence. What does that tell you?
Well, it tells me that the government realizes 2 things. One, the guidelines are calibrated too high, especially in for economic crimes. And 2, they do not, as we were talking about in our prior podcast, they don't want to take themselves out of the conversation by asking for too high of a sentence, which guideline sentences in high loss cases tend to be too high. And another way of saying it is the government is aware that judges increasingly vary below the guidelines at greater rates. The higher the sentence, the higher the loss amount is. And this was a fairly high loss amount case. It wasn't where the Chrisleys were. It certainly wasn't where Balwani was. But $12.5 million is still pretty high, considering that over 90% of all fraud cases have less than $1 million in loss. And Avenatti was found to have $12.5 million of loss attributed to him.
Interesting. All right. So we had a conversation about this in the Balwani episode, which is taking yourself out of the conversation. So the takeaway is even the government's looking at these guidelines and saying, that's just too much. I'm going to make a more reasonable ask that's still a lot more than the other side's asking for, and maybe my argument will prevail. So interesting. And he ends up getting 14 years. So it's like 3.5 years less than the government is asking for, but it's consecutive to the 5 years he's already got in the Eastern District of New York.
Correct.
So basically, where's that ultimate sentence? Where's that going to shake out in the stats?
Well, statistically, he got a great deal and he didn't. And this is the difference. What we're going to discuss is the difference between parity and disparity, but in the sense of looking at similarly situated and dissimilarly situated. And the point is that that defense counsel needs to look at both. And here's why. And this is a good example, actually, with respect to Avenatti as well, why you need to look at both those that are similarly situated and those that are not. So just a quick refresher here. This was a sentence.
So, by the way, sorry to interrupt.
Yep.
I always do the same spiel, but a lot of people are listening to this audio only. Mark is famous for his amazing, incredible visual aids, his charts. So either check us out on the YouTubes on Set for Sentencing. This whole episode's there. You can see them, or go to the show notes at setforsentencing.com. Go to this episode's show notes, and I'll pop those charts in there too. Go for it.
Okay. So what we're looking at here is a comparison of sentencing ranges. We discussed this in detail with Balwani. I'm just going to focus here on Avenatti here on the left-hand side. Again, this was his, as you discussed, Doug, this was his sentencing range under the guidelines, and this is what the government ultimately imposed. But as we know, and as you had stated, this is 168 months that's going to run consecutive to his 60-month sentence that he received in the Southern District of New York. So really, his total sentence is 228 months. But nonetheless, that is still well below his guideline range, which was 262 to 327 months. So the point is, even adding the 60 months here for his the Southern District of New York conduct, it's still a below guideline sentence. So in that sense, he got a break. And also, if we look at those that are similarly situated to him, and I looked at all the data, and this is kind of an ugly thing we're looking at here. This is raw data, and I generally don't show the raw data because it doesn't make sense to anybody. And I like to do the pretty charts. But here, there were exactly 5 defendants since 2006 that were sentenced that had the same final offense level as Avenatti, which was a 37, and were also in criminal history 3. Now, most federal defendants overall are in criminal history 1, especially those that have committed an economic offense. But Avenatti was in a criminal history 3 because of his prior conviction in the Southern District of New York. So that put him in a very rarefied field. So there aren't that many defendants that we can look at that are exactly similarly situated to get some data. And again, there was only 5. But even here with those 5, the average sentence was 271 months, and the median was 286 months. And he again got 228 months total. So he's still, statistically speaking, from those similarly situated, this is a break. But this is why you cannot just look at those that are similarly situated. You need to also look at those that are dissimilarly situated. And I'll show you exactly why, too, and why it's important to inform the court here. If we look at so what we're looking at here is a chart from the U.S. Sentencing Commission's, it's a table, from the U.S. Sentencing Commission's source book on federal criminal sentencing from 2021, the last year available. And again, I want you to focus on 228 months because that's the total amount that he's going to do between the 2 cases. Down here is murder. He's going to be doing close to the median sentence for murder, even though he got a break under the statistics from the guidelines. When we look at that, nonetheless, with those 2 cases together, he's looking at the equivalent of murder. Now, if we looked at just the 168 months he was sentenced to, that's not too far off of what one would get for murder in criminal history category 1, and more than kidnapping. And you look at some of these other violent offenses like manslaughter. If we go out here to criminal history category 5, and again, there are only 3 defendants, but the average sentence for manslaughter was 108 months in criminal history category 5, and he's going to be doing over twice the amount of that. So the point again simply is this gives courts also another ruler or another unit of measure, rather than just looking at those similarly situated. It's just as important. The corollary to that is you don't want to sentence dissimilarly situated defendants similarly. And so Avenatti here, if he had used some statistics, likely could have gotten a much lower sentence. And he was arguing for a 72-month sentence. And probably the court didn't realize, because the courts are not, judges are very busy, and they're not statisticians, and they're not poring over all the commission's data all the time. But, if Avenatti had looked at this and had shown the court that even a 168-month sentence was, almost akin to the average for kidnapping, or it was more than the average for kidnapping overall. If you look at everybody sentenced for kidnapping throughout the United States last year, the average sentence was 166 months, and the median was 121 months, and he's getting more than that just on the California sentence. And so I think that could have carried a lot of weight with the court here, and maybe helped him to get closer to that 72 months that he was asking for.
I'm still trying to wrap my mind around the fact that he got such a high sentence, but got such a guideline reduction sentence. That's
well. But here I think I can explain that inconsistency. It shows how screwed up the guidelines are, especially in economic offenses, that they overemphasize loss.
Yeah.
And so yes, he got a significant downward variance, and he got a lot less than the average person did, but that's only because the guidelines are just crazy high.
Yeah.
For economic offenses.
Right.
When you look at other violent offenses, look at child pornography. Look at child pornography, which is probably the ugliest federal offense there is out there. And look at what people are getting. He got more than a recidivist child pornographer in criminal history category 4. And he got almost what they got in criminal history category 5. Technically, he got more than that if you add in the New York conduct.
Yeah.
So I'm sorry, I got to move this here, and let's look at. And here's criminal history category 6 for child pornography last year.
Which means, by the way, for people who aren't playing the home bingo edition, you have so much criminal history. You've been in trouble so many times in the past that you've buried the needle. That's the highest criminal. The guidelines increase if you have prior convictions on your record. So the criminal history category 6, go ahead.
Yeah. So at criminal history category 6, the average was only 211 months, and the median was 204 months. So by the court,
child porn, we're talking about child porn.
I mean, this is child porn is arguably the ugliest of all federal offenses there is out there. And if you're in criminal history category 6 for child porn, you're probably one of the worst.
Apparently not as bad as a lawyer who rips off his client.
But apparently not as bad as a lawyer who extorts Nike and rips off his clients.
Yeah.
Now, that should come as maybe not a shock to judges, but that's something that this court should have been made aware of before imposing what it thought was probably a lenient sentence, but it wasn't.
Right. And what you're talking about, because I love to talk about the 3 R's of sentencing narrative, there's different stories we tell, and that's what I call the relativity arguments, comparing this to that. And it is kind of, I don't want to say standard, but it should be standard to compare similarly situated defendants. But what people don't often realize is that what we should do is compare totally similarly situated defendants and say, look at murderers and child pornographers who are faring better under these broken guidelines than a lawyer who stole from his clients.
Yeah.
So make sure you're looking at there's a lot of practice tips. Make sure you're looking at these guidelines from all angles, comparing this to that relativity. I got to say, the other interesting part of this in terms of the recommendations for sentencing comes from the probation officer. So for people who don't know, the probation officer's job is to prepare the pre-sentence report, which does the guideline calculations, has all the history of the person and all the relevant factors that go to the judge to help the judge decide what the sentence should be. But they also make a sentencing recommendation. And it's very rare in my experience that a probation officer is going to recommend a below guideline sentence, or at least or substantially below guideline sentence. But in this case, I think it's important to look at this because this PO basically recommended a 91-month sentence when you factor in. So they recommended 151 months for this offense, but they also recommended that it be concurrent, meaning run simultaneously with the 60 months that he got in New York. So he's already serving that 60 months. So he had 91 months tacked on to a sentence. So they're essentially recommending a 91, and compare that with 210 and all those other numbers. Like what on earth is going on there? Have you ever seen a recommendation like that from a PO?
No. No, but the POs, recognizes the flaw in the guidelines too, and what's going on with sentencing nationwide. And one thing courts can do, and that judges very often do not do, is they can go to the commission themselves and ask for data, and and have the commission run. I'm saying this against my own self-interest, but nonetheless,
that's okay. It makes you credible.
Yeah, the judges can ask the commission to run their own statistical analysis, on a particular case, on a particular for a particular what I call a sentencing profile, in terms of what the guideline calculation is, the criminal history, whether there's any mandatory minimums or consecutive sentences that apply, and particular sentencing factors that apply or don't apply. They can go through all of that and ask, and race and gender and age and all that other stuff.
Well, that's interesting to me because I can't remember one case that I've ever had that I've known a judge to do that. And I say that I've known a judge to do that because I don't necessarily have to know that a judge has done that, right? I mean, he or she could just do that on their own and not even just for their own edification, right?
Well, I think they would have to disclose that if they were doing that in a particular case. They were doing their own research and getting the statistics on that, and they would have to.
I mean, in an ideal world, you would hope so, but I have this pet peeve of mine. I suppose this is a tangent, but not really, where the probation officer technically is an arm of the court. They work for the judge, and a lot of judges will take that PO and bring them into their chambers for what we would call ex parte and one-on-one conversation before sentencing. I did sentencing in Eastern District of Michigan, and the PO walked in, hello, greeted, nice fella, and walked straight back to the judge's chambers. And I sat there for a half hour, knowing that the two of them were in chambers alone talking about my client. And there's no more helpless feeling for a lawyer to say, well, I don't know what they're saying. I don't know if it's accurate. I can't respond. They're not going to summarize the conversation for me when they take the bench. Like, how do you know the judge isn't doing
I think that's a bad
work?
practice. I think that's a bad practice, and the judicial conference should put a stop to that. But yes, I do know that has happened. I have recently encountered one PO that has gone to the commission, and actually, at least to the commission's website rather than the commission directly, and pulled some statistics off the website. And I don't mean like the statistics I just showed you just from like the report, but the commission does have an interactive website where you can get some statistical analysis. It's kind of high level, but nonetheless some useful statistical analysis. And that PO, but I've only seen it one time where a PO has gone out and done that and disclosed it. But you're right, as far as PO giving his or her own recommendation ex parte, I think that's a very, very bad practice. Something that the judicial conference should no longer tolerate. Or the commission.
The other interesting part with back to the PO's recommendation I thought was unusual is not only did they make a good recommendation, pro-defendant recommendation, but the government took them to task for that. And also just in general, they made some comments in their government memo about how they didn't really interview his parents about his abusive child. Like they didn't, basically saying these people didn't do their homework, so don't rely on their stupid recommendation, judge. Which I thought was interesting, because usually that I don't see that happening where the government's going after a PO like that.
Yeah, it's not going to help them in future cases. That's for sure.
Right. The POs are by and large, they're our friends, and we,
Right.
and that they will, they'll work with you, and there's a lot you can accomplish behind the scenes and off the record with them. You don't have to take them to task on the record like that, which is a good segue to sentencing memos, because I've had this deal where I've done it in Holmes, I did it in Balwani, and I do want to do it in Avenatti. I want to just take a look at what's going on in the sentencing memos from a narrative perspective, from a style perspective, from a strategy perspective, right?
Mhm.
And I don't have a ton to say about the governments, but I'll share this. I'll share the screen here real quick. So real quick, we have highlight in yellow, highlight in purple. The first, I guess I'm a conservative, Mark, because I believe in conserving words and conserving space.
Yeah.
And don't waste space and don't waste time, but you get to the point. So this yellow paragraph, defendant Michael John Avenatti is due to be sentenced following his pleas of guilty to 4 counts of wire fraud in violation of 18 U.S.C. 1343 and 1 count of obstructing the due administration of the Internal Revenue laws in violation of 26 U.S. Like, come on, we know that. So I would say, government, I'm sorry, your opening paragraph sucks, but you did redeem yourself in the second paragraph. It's actually pretty good. So this is a pretty good example of how we need to come out of the gate and tell a story, frame the issues, give us context, set the stakes, grab us, hook us, and give us a roadmap for, the whole journey that we're about to take here. So this is not so bad. This is actually fine, decent, right? Congrats. Defendant, a now suspended plaintiff's attorney, stole from his clients instead of advocating for them. It's a good opening, right?
Yeah.
Although the details pertaining to each of the 4 clients underlying the charges and the indictment differ, the general pattern is the same. Defendant would lie about the true terms of the settlement agreement he had negotiated for the client. He'd conceal the settlement payments that the counterparty had made. He'd secretly take and spend the settlement proceeds that belonged to the client, and then lull the client into not complaining or investigating further by providing small advances, in quotes, of the supposedly yet to be paid funds. Through this multi-year fraudulent scheme, the defendant stole millions of dollars from his clients. So that's pretty darn effective, because what it does is it paints a very stark portrait of who this person is and what his crimes are. And it's obviously exponentially gross because he's a lawyer.
Yeah. Right.
He's a lawyer. His main duty is to protect his clients, and he betrayed them. He betrayed them, right? Yeah. And the government's very good at weaving a theme throughout, which is what? Greed and arrogance.
Yeah.
And they have plenty to go on in terms of, what a public figure he was. And he was, was just a very confident person, but the government's reframing that narrative as greed and arrogance. So anytime they can, and this is part and parcel of our fraud charges, but anytime they can focus on lavish spending, private jets, big, beautiful homes, fancy sports cars, that's like them just sticking the knife in and twisting it, right?
Well, they nailed his hubris.
Yeah, right. And compare that with Holmes Balwani.
Yeah.
Was this about, maybe it was about ego because they didn't want to fail, but really no, this is really just about, it's not about greed. It's not about, I don't think, especially for Balwani. So it's a relativity thing. And then they go into some serious detail. Now, in narrative, details are everything. The more detail you can bring into a story, the more powerful, immersive it's going to be. And they're not just talking about clients who got defrauded. They're talking about clients, in one case, who's a paraplegic, with mental health issues, very vulnerable clients. We're talking about a guy who was injured in custody and left as a paraplegic and tried to commit suicide. So these aren't just clients who are at the mercy of their lawyer. They're some of the most vulnerable people in society that he's preying on and gaslighting. You'll get your settlement later. So it's just levels and levels of deception and greed and gross. And they're doing a good job painting that. And I think at the end of the day, when you think about how high his sentence is in comparison with these other people we were talking about, that's what's at the core. And thank God, I feel like, thank goodness, the prosecution hasn't caught on to visuals and sentencing videos and things like that, because if they would have woven some powerful visual images of these clients, devastation.
Yeah,
I don't know if they're in court.
Well, yeah, if they had, Avenatti very well could have ended up with a guideline sentence.
Yeah. The other thing I thought was interesting was RDAP. We've never talked about RDAP. I touched on it briefly in the episode that I did with Walt Pavlo and the prisonology folks, because we were talking about it in the context of these so-called experts who say, give me money and I'll make sure you get into the RDAP program, which is the Residential Drug and Alcohol Treatment Program, which gives them, if you can get into the program and complete it, you get time off your sentence, right? So Avenatti was asking for it, but we had a problem there. Now keep in mind, the core allegation here is lying. It's deceit. It's fraud. It's greed. It's hubris. So he's saying, oh, please give me the drug and alcohol program because I have an alcohol problem. But there's a little bigger problem, which is when you get arrested for this, you're under pretrial supervision. So hopefully you're out and about and you got to report to the court. And they ask you all those questions. Do you have a drug or alcohol problem? And he said, no, I'm cool, man. And why would he say that? Because I know if I tell them I have a drinking problem, they're going to put a condition on my release that won't allow me to drink. And so I want to drink. And so he lied. Ostensibly, the takeaway is he lied. So I guess practice tip, if you're going to ask for RDAP, having never previously disclosed a history of substance abuse, you better have a good explanation for that. You better come in and you say, Judge, I know we didn't talk about this before, and here's why, but this is a real problem. And maybe the story is I hadn't come to terms with it. I just never thought of myself as a person with an alcohol abuse problem. And I'm looking at my life in a whole different way, Judge. I've gone through this and coming to terms with my behavior and what got me here, what led me here. This is real, right? But don't just say no there and yes there and think that it's going to come back on you in any positive way, because the government seized on that and said, Judge, the guy is a fucking liar. And this is just one more example of why he'll just lie to get what he wants all the time. And that's never a good way to posture yourself to get before a judge for sentencing, right? Okay, right. So how do you feel about the fact that Michael Avenatti represented himself in this case?
Something about a fool for a client. How does that go? But I mean, to be honest with you, I mean, he wrote a very long sentencing memo, but as we've discussed quite a bit now, that's not necessarily a good thing. It was 54 pages. He is an attorney, so he's a plaintiff's attorney. He spent a lot of time on objecting to various guideline enhancements, and I'm not saying that's a bad thing, but 54 pages is probably too much. And what he this, by the way, is another good thing about pleading open or straight up, is that you preserve that right not only to appeal but to object to certain guideline enhancements. Whereas in most plea agreements, you have to stipulate to certain guideline enhancements. So there's the only thing you're left arguing, if you're left anything to argue, is just ultimately what sentence to receive. But here, because he pled open, he was able to preserve his right to object to the sentencing enhancements. but I think he overdid it by a lot. And as a result, he didn't leave any space or not enough space for some of the more substantive arguments that I think could have helped him, one of which we already discussed was statistics. But the other, of course, is his life expectancy. He spent, a total of, and I can't fault him for that this much, by the way, because you see this with experienced counsel too in federal criminal cases. But he spent a total of 6 lines discussing what his age upon release is going to be.
Yeah.
Whereas, and I'm going to bring up his life expectancy here in a second. That would have been a lot more impactful and helpful to him if he would have showed the court, not only the statistics that we discussed, but also what his actual life expectancy would have been or is going to be. And here we could see again, applying the Patterson study, which we've discussed in the past, is a peer-reviewed, published study by a professor at the University of Syracuse that found, after reviewing tons and tons of data from inmates, that inmates on average lose 2 years of their life expectancy for every year they're incarcerated. And Avenatti is 51. Actually, now he's almost 52, 51.8 years. His life expectancy as of today is 82 years. So he's expected to live about another 30 years. But if his life expectancy decreases 2 years for every year of incarceration, you can see that's only going to get him to about 2033, statistically speaking. And that's a lot less time than what his just 168-month sentence was for. And so this is something very important, I think, for courts to consider, especially for older defendants like Avenatti. Those inmates that are 50 years or older going into prison for the first time are considered elderly inmates, believe it or not. They're going to, as we get older, as we know, we have health issues that just go along with the aging process, and we're going to be more susceptible to things like COVID and other infectious diseases while we're incarcerated. And our life expectancy is going to get even more shortened as a result of that. So, the court obviously here didn't and could not sentence Avenatti to a life term of imprisonment, but effectively the court has, at least statistically speaking. And this is something that courts should be made aware of. And it's unfortunate that and all the effort and the good objections that Avenatti raised in his sentencing memo, out of those 54 pages, he just devoted 6 lines to say he's going to be, old guys don't recidivate, and didn't make this specific to him. Yes, old guys don't recidivate. You know who else doesn't recidivate, Your Honor? The dead
guys.
Yeah, dead guys don't recidivate either.
Mm-hmm.
So, this is something that would have been very powerful for Avenatti to include. And I think that any defense counsel needs to include this, especially if they're talking about older inmates. And older inmates aren't through 70 and 80-year-olds. They start at 50. Those are considered elderly inmates. And we at least I don't see this very often in looking at sentencing memoranda from across the United States, that this issue has to be emphasized, and courts need to be made aware of it, because I don't think judges intend to sentence people to life terms of imprisonment or de facto life terms. If they do, they're going to throw out a really big sentence here. But even though 14 years might seem big, and it is relative to other sentences or to other defendants, I'm sure this court thought that at the end of the day, Avenatti is going to have a life outside of prison. Statistically, he's not.
Yeah. And this matters to judges. I remember the first time I saw this come up in a case, and I was kind of a baby federal defender, but the judge pulled out an actuarial table and said, my client was 78 years old, and he said, based on life expectancy, he has 7 years left to live. And at that point, I never even thought of raising a life expectancy. I was a baby. We don't know what we don't know, right? We can't fault, like you said, we can't fault the lawyers for doing that. And this was before the Patterson story ever came out. But the lesson to me was judges care about this. And so we, knowing that judges are human beings and they don't necessarily think a person should die in prison for whatever they did, this should be something we raise in every sentencing. And I don't think we didn't see it. We didn't see it in Holmes. We didn't see it in Balwani. We haven't seen it here. We're not seeing it in Chrisley. We'll talk about, like, we never see it unless we're doing
unless we're doing it.
Unless we're doing it. So, okay, good. So I'm going to put that chart in the show notes too. It's setforsentencing.com.
And so just for your viewers or your listeners that aren't viewing. So basically what the chart shows is that Avenatti only has about 10 years left. And his total sentence, as we now know, is 19 years. So statistically, he's going to be able to serve barely half of what that sentence is.
Yeah, and even if he earns good time credits, first step back credits, and all everything else,
right? So pleading guilty didn't. What this other thing shows is pleading guilty didn't even help him. Yeah, even with getting those the 3 levels off for acceptance of responsibility wasn't even help.
Yeah,
might as well have gone to trial.
Yeah, or maybe gotten a much greater benefit for not putting paraplegic with mental health issues on the stand, forcing them to come to trial and go through that whole exercise.
Correct.
He saved a lot of people a lot of heartache and the government a lot of expense by just falling on his sword and pleading guilty. So, what's that worth?
And now he's another body in an overpopulated prison population, helping to spread COVID and God knows what else.
So I'm going to share. So I talked about the government's memo. I'd like to talk about Mr. Avenatti's memo because he is a lawyer. He's not a criminal lawyer, but I think he did some pretty good stuff here. So defendant misappropriated monies due 4 of his legal clients, misled them repeatedly, and violated their trust. I mean, listen, mea culpa is the name of the game at sentencing. I'm here to tell you I've messed up big and I'm not here to make excuses for it, and I'm sorry. So I can't really think of a better way to come out of the gate than that. And in doing so, he keeps going. He put his own selfish interests ahead of his clients, committed federal crimes, and broke some of the most important rules governing attorneys in the state of Arizona. So he doubles down on his own culpability, and I love it. He also impeded the ability of the Internal Revenue Service to collect taxes that were due. He deserves just punishment for his crime, including a prison sentence. He deserves to lose his law license, his 22-year career, his assets, his countless personal and professional relationships, and his reputation. Almost all have been rightly taken from him. So he triples and quadruples down.
Yeah.
And he's doing it in kind of something interesting, which is to say, look at all I've lost, not to say, poor me, which is to say, yeah, I had that coming, but I lost it all and it's my doing. So I think as far as opening paragraphs go, I love it. I think he diminishes himself a little with the next paragraph because there's a however. But I must say, which is, this isn't horrible because it says he deserves to be sentenced according to the law and similar to other defendants. There's your relativity, if not, albeit incomplete relativity argument, but sends them to other people who've committed these. This is exactly what we've been doing for, this whole thing is look at these.
And Doug, I'm sorry to interrupt, but this is where, excuse me, what would have been most helpful for him. See if he could have used a couple of examples of those individuals that were similarly situated to him that got 72-month sentences, which is what he was asking for, as well as those that were not similarly situated to him that committed far worse offenses that got 72-month sentences.
Yeah.
That would have been so powerful right here.
Yep. So there's nothing wrong with pointing that out. Then he says he should be sentenced based on his life as a whole across the last 51 years. great. That's what we do. That's 3553. It's history and characteristics. And then, but it's sort of him saying, what's going on here is my notoriety, the government's trying to make an example of me, unbridled vindictiveness. He's saying there's unbridled vindictiveness, and what those in the media or social media may say after his sentencing. So, he's basically saying I'm a public figure and, this is vindictive. And I don't know, I think kind of falls a little flat for me, that part. But I do love where he started.
Yeah.
And, on the whole, I'm going to give that not bad marks, right?
Oh, he's a good writer. Well, given that.
Yes.
Yeah.
Here's my couple of little things. So guess what? He used pictures. So it's great. The only thing that drives me crazy, and I teach this all the time to lawyers because we are taught so wrong in law school. We're instilled this sort of lawyerly way about us. So what he does is he puts some pictures in there, and he put them at the very end of his very long memo, which was check out exhibit N or whatever this was. And
you mean he put them in the exhibits?
Yeah. You put them in the exhibits. And I say, why are you doing that?
Right.
You're doing it because that's the way we've been taught as lawyers to be lawyerly. And this photo of your family is some sort of evidence, and it's an exhibit, and exhibits go all the way at the end behind a sheet of paper that says exhibit N. And so what you're doing is you're relying on the faith that whoever's reading this is going to stop what they're doing, or sometime later go flip all the way back to the end and find exhibit N and look at that picture.
Right.
Why would you not just put the picture in the body of the text so it's right there in your face for the minute that you're on that page?
Correct. That's right.
Why not?
Judges are human.
There's no rule against
it. Are human too. Right. Exactly. There's
no rule again. If you really want to, you could put right underneath that picture exhibit N. if you really feel compelled to be that lawyerly, that's fine. But put it right in the body. That way, you're leaving nothing to chance. And for that minute they're on the page, that image, that humanity is being seeping into the reader's consciousness. It's way better. It's a small little point, but I love to emphasize it anytime I can because it's important. But here's the biggest complaint that I have here. Where's the story? We have this ultimate fall from grace. We have the government's narrative untouched. The government's narrative is what? Greed and hubris.
Right.
And we have something that I call, Dr. Randy Olson calls Shirley's Law, but I talk about it in my narrative work, which is you have to control the narrative. If you give up control of the narrative, someone else will tell your story and you're not going to like it.
Right.
And we already know the government's got control of the narrative, and this is the story they told. You're a greedy person. You're a person filled with hubris. And so what he has done is missed a giant opportunity to help tell what we call the revelation story. We did relativity, right? Which is comparing this to that, but the revelation stories are revealing often hidden truths, something we don't know about the human being that helps give context to how they arrive in this moment in time.
Well, like Alan Ellis says, and I'm sorry to interrupt again, but he always focuses on this. Judges want to know the why. And this was Avenatti's opportunity to say why. And maybe it was greed and hubris. Well, as Alan always also says, own the mistake. Yeah. And this is what Avenatti did do in that first paragraph. But you're right. He didn't run with that and explain the why.
And if the why is greed and hubris, you have to tell a story about how you become that person.
Yes.
You're not born bad. You're not born a greedy, well, you need food. You're greedy for food, shelter, and love. That's as much as you're greedy for. So what along this journey crippled him, broke him? What tainted him? What poisoned him? And as any human being goes, like when we make major mistakes in our lives, don't we always just go, man, if I would have fucking gone left there instead of going right, I never would have had that crash. But we always are in our mind trying to figure out how the fuck did we end up in this mess?
Mm-hmm.
And that's an exercise that I feel like all of our clients should be going through. And it requires a whole lot of introspection and a whole lot of honesty, but it reveals this layer of connection. Like, we all have done things we're totally ashamed of in this lifetime. So the question is, what brought you to this moment? And then I think the more important question is, what are you going to do about it?
Yeah. Right.
And those are
Right.
our redemption stories.
Right.
How am I going to make this right? And I didn't see any of that.
Yeah.
I didn't see any of that here.
Mm-hmm.
And when you talk about how I'm going to make this right, then you're communicating that not only am I owning the mistake, but I'm a person that's worthy of redemption, that I care that I did this.
Mm-hmm.
I care about the people that I hurt, and I'm going to spend my life trying to fix it.
Yeah.
So I didn't see any of that there. So basically,
and what is he going to do if, this is something that I've seen, but rarely, but I think it's very powerful, is, Your Honor, if you're going to impose a custodial sentence on me, this is what I plan to do while I'm in prison. I'm going to take advantage of this. I'm going to take these courses. I'm going to help other inmates learn how to read or get their GED, or organize their finances, things of that nature, something to show that the time in isn't just going to be sitting there stewing, but you're going to do something with it, do something positive.
Yeah.
And not just once
thought.
you're out.
Yeah. You've
given it thought.
And you have a plan.
Right.
So I don't know, missed opportunity. All of those things, your relativity stuff, these revelation, the redemption stuff, missed opportunities. He totally could have come out of this with a better sentence than he got. I guarantee you he could have come out.
And you can do that in less than 54 pages. And it certainly helps to do it with a video too.
Yeah. I don't know if a video, I mean, maybe. I love the images in Balwani that came to mind with the orphanages and the water and I was seeing that movie in my head. I can't quite see Mr. Avenatti's movie in my head, but I don't know enough about his life.
Right.
And that his life is a mystery to me.
Mm-hmm.
I know that he grew up in the same town that I did in St. Louis. I was trying to learn about him, and I moved away when I was 10, but he was 1 year apart from me, and we would have gone to the same high school, Parkway Central. And he had a seemingly normal upbringing, which I guess a lot of people could say, but is probably never true. I mean, I don't know. I don't know, but we know it's a mystery. And what it is leaving the government's narrative untouched.
Yeah.
Wow, what a missed opportunity. So I'm sorry that this happened to Mr. Avenatti. I'm really sorry, because I hate when a lawyer gets in trouble, because it perpetuates the stereotype and makes the rest of us look bad. And I'm sure that's underlying a lot of what happened to him in terms of his punishment. But it is a lesson for any defendant who's getting sentencing. There's always a story to tell. There's always more we can do. I'm going to bid you adieu for this portion of Set for Sentencing and say thank you. Go to the show notes, go to setforsentencing.com, check out Mark Allenbaugh at sentencingstats.com, and he's going to be back here in a hot minute so we can talk about Chrisley's, so we can talk about Mr. Donald Trump and the criminal referrals from the Congress, and SBF, Sam Bankman-Fried, yes. Bankman-Fried, because he's got a lot of troubles too. So,
oh boy,
man, there aren't enough hours in the day. We'll be back soon. Thank you so much. See you next time on Set for Sentencing. Peace out.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff, who loves the inside scoop on how this whole thing works. I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.